Training room. We appreciate your participation in our program today. We have Judge Franzak, who has prepared, along with Sheila Schwanekamp, a presentation for IDV court. Some of you folks have been selected to be on a specialized IVD panel, which Yvonne and I have put together with input from the court with regards to the type of cases that are handled there and the specialized training that's really required to provide the best representation for our clients that we can provide, because there's a potential continuing representation that would go forward in the family court scenario. So we believe that this would be a training that would be best suited for everyone. We appreciate you coming out. We know the weather is not so pleasant today. For all of those who hopefully will be viewing this on flash drives, for the rest of the folks that were part of this program that have either volunteered or we had asked to be here to participate in the program and that are not present here today, we will be mailing out both the certifications for the CLE credits and the feedback, the responses, along with a flash drive that you'll be receiving in the mail. You'll be able to view this and then respond accordingly, but we would hope that you get that evaluation back to us as quickly as possible so that we can get this panel up and before the court. The court will be utilizing the panel to make assignments from the bench. So what will be happening is, if a case comes in from town or village courts and the court deems that the case is appropriate for IDV court, the attorney who was originally assigned in the lower court will be asked, or will be relieved, and one of you folks will be taken on the case. And that representation will go through the court, making the assignment off of the bench panel list. So that's how those assignments will take place. Periodically, as the need either increases or decreases, we will rotate the panel. If more individuals want to be part of this IDV panel, we will have the training available on our website, which hopefully will be up soon. And again, it'll be available on flash drive. So we'll rotate the names and list panel attorneys off that and on that list as deemed appropriate. So I don't know who's going to speak first, Judge.
I believe Sheila's going to go first.
So Sheila Schwanekamp will deliver a presentation from the court's point of view with regards to IDV cases. I believe her presentation, I hope I'm not speaking out of school, I haven't reviewed her paperwork, but I'm guessing that it'll entail what type of cases the court views, how the procedure is that they implement to determine which cases will land before them, and what they expect of the attorney who's representing on these cases. So with all of that being said, I thank everyone again for coming out. We really are striving to create these specialized training programs and utilize our resources that ILS has given us through the Harrell hearing and just the training room itself and the facilities that we have here to best serve our clients and you, the panel members. So we thank everybody and we thank our panelists for contributing today. And with that, Sheila.
Just a few comments. I just wanted to just fill in the blanks as far as Sheila goes, because she and I have history. We go back a few years, right? Sheila is the court attorney referee for the 8th Judicial District. And I would dare say that she probably knows more about IDV courts, how they work, and the law that pertains to it than anybody I know. She's just a font of information and a mainstay of the court system. I had the pleasure of working with Sheila when she was the chief law clerk over at Buffalo City Court, so I know firsthand the quality of her intellect and her lawyering skills. We've done a panel or two together, so it's always been my pleasure. I think going back to the days when I was a prosecutor in the care unit, even in the 1980s, I'm dating us both. So I think we're very fortunate to have Sheila give us her perspective and insight into the IDV court. From our brief conversations, it's my understanding that among the topics she'll be touching on are so-called evidentiary risk factors, the effect of domestic violence on children, and the factors that play into decisions to include children in orders of protection. Is that right, Sheila?
Correct.
So, if you would, please, Sheila.
Good afternoon, everybody. First of all, it's an honor to be here. Thank you all for taking the time to be here for this IDV panel. I want to thank Dan, Yvonne, for the opportunity to meet with all of you today to share with you some insights about the IDV court. And also, I am so excited for all of you to know that your Dean of Education and Legal Training is Judge Franzak. Judge Franzak and I have worked together. He was my boss. He's very kind to say that he's worked with me. He was my boss in city court when I was a law clerk, and we've had the opportunity to be on panels before. So that being with you today is just a wonderful opportunity, and thank you to each and every one of you. I know that all of you have great expertise in the law, in family law, in criminal law, and today my purpose is not to give you a training on how to handle a domestic violence case. You've got that, but what I have provided in the purple folder is an update on the law, the laws that have been implemented, over the past several years, and I'll just give you a brief update on that. But what I really want to do is bring you information that the judges have been receiving at trainings over the impact of domestic violence on children, on risk factors, give you a little background on how the judges are looking at risk and lethality in domestic violence cases and how that was developed based on evidence-based research. I think it's really important when you understand, and I've had a lot of you in pretrials as well, where you're hearing, wait a minute, where is this coming from? And I think, it's our responsibility from the court's perspective to make sure that you're aware of this information. Not saying you have to agree with all of it, but I think it gives you some insight as to where the court's coming from on these cases. And then you can make decisions, on how you want to prepare your clients going forward for these cases. To start out, I think most of you are aware of the fact that the integrated domestic violence courts were developed in the 8th Judicial District starting in 2003. The IDV courts are accountability courts. They're not treatment courts. So they're based on the concept of complainant safety and offender accountability. And it's really important because I know we do hear at times that there's a request from counsel, well, can't you just send this case over to the drug court or the mental health court or the veterans court? Those are treatment courts, and they have a different goal, they have a different way of monitoring. As you know, in Erie County, we have a resource coordinator. So when there is a directive to either probation or the court's making directives for substance abuse or mental health evaluations or a domestic violence program, those are arranged through the resource coordinator, Colleen Gibbons, in Judge Hendage's part. And I also want to note, too, that if you aren't already aware, because of the volume of cases in the IDV court, Justice Mark Montour also handles 25% of the IDV cases in Erie County. So you may have cases either with Justice Hendage's or Judge Montour. But both courts follow, the same premise of complainant safety, offender accountability. Both have the same staffing of the resource coordinator. So when you do have those issues arise, if somebody's a veteran, if somebody has mental health issues, if somebody has substance abuse issues in the context of an integrated domestic violence case, the case is going to stay in the IDV court, but those referrals can be made and the monitoring, will take place. Also, in 2003, we had a 6-month planning process to put the IDV court together, and we were actually a pilot court at that time. Since the Erie IDV court started, we now have 8 IDV courts in the 8th Judicial District, so every county has an IDV court. They're all premised pretty much on the same model. Erie County is the only full-time IDV court, but if you've been in other counties, you'll know that it's following the same model. Again, same staffing, same premise. The jurisdiction of the IDV courts is pursuant to the rules of the chief judge of the state of New York. So it's Part 41, and the implementation's under the rules of the chief administrator of the courts under Part 141. And basically that sets the parameter for the transfer of the cases. You have to have a criminal domestic violence case in order to be eligible for transfer to the IDV court. So if you have a criminal IDV case, a criminal domestic violence case, and you've got a pending family court or a matrimonial, and usually the family court matters are the family offense and the custody cases. Once in a while, the IDV court will take a neglect case in, but that's really a rare occasion. But if you have the pending criminal case and you either have a family court matter or matrimonial that's already started, or it starts during the pendency of the criminal case, then those matters are eligible for transfer to the IDV court. The standard for the transfer of the case is to promote the administration of justice. So it's a very broad standard that the IDV judge looks at. Many of you have been in IDV court, and maybe you have spoken to the judge's law clerk to say, oh, I've got a case that could be eligible for IDV. Unfortunately, our computer systems don't talk to each other. So there's a lot of manual linkage. There is in Erie County a court clerk who's actually doing the searching of cases from the originating courts and trying to cross-reference them with family court matters. It can be a challenge because unless the names are spelled exactly the same, it's not going to come up in a computerized system. So there's a lot of manual searching. The court gets calls from victim advocates, police officers, from attorneys to say, I think this could potentially be an eligible case for transfer to IDV. What happens is the paperwork comes to the IDV court from each originating court, and then the judge's law clerk is usually screening that and then talking to the judge about the transfer. It's not up to the originating court to make the decision on the transfer, it's up to the IDV judge. So Judge Hendages is making those determinations as to whether or not those cases are going to come forward. When we first started, we also had, some challenges like, well, how can, this court handle cases that started out in a city court? And, where's your jurisdiction coming from? Actually, the IDV court jurisdiction has been upheld by the Court of Appeals in a case called People versus Korea, which is 15 New York 3rd 213. That was back in 2010, which upheld the jurisdiction of the Supreme Court judge who was assigned to the IDV court to be able to handle all cases, including the misdemeanors and the violation levels. And then it was further amplified in a case called People versus Ford. Justice Hendages also wrote a decision, 32 Miscellaneous 3rd, 674 from 2011. So that really gives you some background. I do want to also note that when we were going through our planning process, not only did we have court teams together doing all the planning, but we also had stakeholders, and we had a lot of legal stakeholders. So we had the commitment of the DA's office, assigned counsel, legal aid, private counsel, private attorneys, and we had a lot of presentations. But since that time, a lot of the people have moved on. So again, thank you for taking the time to come here and hear about this. And we should be doing this more often so that everybody is on the same page and can understand what the IDV court is about. Also, several years ago, under Bob Lonsky's leadership, the IDV panel started. And a lot of the attorneys have moved on. So again, thank you for your willingness to be in the IDV court. What makes an IDV panel particularly helpful is that, and your experience probably helps you understand this too, is that if you have the information from the criminal case and the civil case, the family case, the court has all that information. So it's going to help you better represent your clients. Whether or not you're representing the defendant who may be a petitioner or respondent in the family court matter, to have more of that information, it also helps you. So again, we're very grateful to you for making that commitment. In your packet, there are some legislative highlights. I'm just going to briefly go through a couple. I want to give credit to the OCA counsel's office, particularly Janet Fink. Every year, the judges get information from OCA as to new legislation that's been enacted. And so what I did was I took from that huge compilation, I pulled out the legislation that pertained to domestic violence. And there's pages of that. I'm not going to go through the whole thing right now, but I just want to mention a few recently enacted statutes. Back in 2019, the new law, the revenge porn statute, was implemented. It's Class A misdemeanor under Penal Law 245-15, and it's also listed as a family offense in the Family Court Act. And that's the unlawful dissemination or publication of intimate images. Also, there is a new bill that was passed that recognized that older victims of domestic violence who may be experiencing financial abuse can come to family court. And the family court order of protection can issue a provision that the matter can be scheduled for a hearing on temporary maintenance within 7 business days. So that's something new. In other cases, as you may know, the family court does have the authority in a family offense case to issue a temporary order of support, even on the order of protection for a very limited basis. The practice in Erie County is that if that is done, the petitioner needs to file a support case right away that can be heard before a support magistrate. But if there's a need for an emergency temporary order of support, that can issue on an order of protection in family court. Also, to clarify, the support cases, if it's not going to be transferred to matrimonial, are going to stay in family court. There is federal funding for the support magistrates, so when the IDV courts were developed, it was determined at the state level that the support cases would not be transferred into the IDV court. They'll stay in family court, but we have IDV support magistrates. So John Amen and Julie D are the IDV support magistrates. What happens is if family court becomes aware that there's pending IDV matter, the case will be transferred over to Julie or John to hear. And they will communicate with the IDV court. And if there's any objections filed to their decisions, then that goes to the IDV court judge to hear those decisions. Also, there's new legislation. I think this is this was interesting for defense attorneys. Sentencing and resentencing of domestic violence offenders. That was the laws of 2019, and the penal law was amended, section 60.12. It's amended to authorize alternatives to mandatory sentences for cases in which an offender was a victim of domestic violence. So it's a new section 440.47 to the CPL. It permits offenders to seek resentencing in accordance with the alternatives where they were victims of domestic violence and the domestic violence significantly contributed to the commission of the offenses. So that's something very new. I haven't seen it applied yet, but that was taking effect as of August 12, 2019.
We've had a couple cases. Paul Dell had one with Ann
Okay,
and it was in front of Judge Biscaglia. Why don't you tell us, Ann, real quickly, because I think it's right on point, and I think Jessica Culprit just had a case take a plea where that's gonna
Yes.
be a
Yeah,
factor.
she's having a hearing actually in her matter. We didn't have a hearing in ours because there was a full jury trial. So the judge had heard all of our witnesses during the course of the trial. And then he declined to apply the statute, but gave her client 8 years on manslaughter, so.
okay.
And then Jessica Colpitz is actually having a hearing with an expert, and that's coming up in April. I don't know what the date is.
That's gonna be interesting how that
Yeah.
plays out, but that's a brand new law
Yeah.
as of last year.
Yeah.
Very good. Also in 2018, there was a new process for firearms possession, surrenders, and returns pursuant to CPL 37015, where the DA's office is required to give notice of a qualifying charge within 45 days of arraignment. And then on a conviction of a serious offense as defined in the CPL, the court must inquire of the defendant as to the existence of all firearms, rifles, shotguns that the defendant owns or possesses and order the surrender of the weapons. And the court then is required to notify local police and state police and direct law enforcement to immediately notify the court upon the surrender. The defendant does have a right to a hearing, and hearsay is admissible for those hearings. I'm not going to spend a lot of time. You do have the outline. Again, in 2017, there was legislation on the translation of the orders of protection. So the orders of protection are issued in different languages now. Laws of 2016, the penal law was amended that possession of a machete is now a Class A misdemeanor for criminal possession of a weapon for. What we're seeing is not only are there a lot of domestic violence fatalities involving the use of guns, but there's a lot of use of knives. And I would just point out, last year in Erie County, there were 14 domestic violence fatalities. And some had some connections with the courts, others, there was no connection at all. But many of these involved the use of a gun or knives. We're seeing knives and strangulation happening more and more. In 2015, there was the reauthorization for the video conferencing request for an ex parte order of protection from family court. We have that process here where a litigant can go to the Family Justice Center, domestic violence victims at the Family Justice Center, and they can seek an ex parte order of protection from family court. There is an attorney from Neighborhood Legal Services at the Family Justice Center who may be assisting the victim with the preparation of the petition. Not sure if that attorney is still going to carry over when the case is assigned to family court. I think those protocols are still being worked out. But if you are assigned in those cases after they come over to family court for further appearances, of course, counsel always has the right to amend the petition that originally comes in. Laws of 2014, aggravated harassment second, GPS tracking is a form of stalking, and in the laws of 2013, the notices on the orders of protection, it clarifies that an order of protection is in effect even if the protected party consents or communicates with the defendant. Sometimes we'll hear, well, the protected party should be charged because they were contacting the defendant. I know it makes it difficult for the defendant, but it's not a charge. It's, the protected party cannot be held to violate the order of protection. Also, there's new charges of identity theft, grand larceny, and coercion are listed as family offenses. Back in 2013, there was the SAFE Act, and there's also an address confidentiality statute that was enacted in 2011 so that a domestic violence victim can seek the use of the Department of State as their address for an agent, as the agent of service, so that if there's safety concerns with disclosure of their address, that can help protect their location. And back in 2011 is when we saw the implementation of the strangulation and criminal obstruction of breathing charges. In the past, historically, they were often charged as harassment, as choking. And with the research, the evidence-based research that's happened, that's really made a lot of change in the legislation. So now you have them as felonies and Class A misdemeanors. So that's just a brief outline. All the legislation that I compiled is in your outline for you to review at another time. We've talked about the transfer of the cases to the IDV court, but once the cases come to the IDV court, it's important for each of you to know there's a big IDV file folder, and within the file folder for each family, there's a section for the criminal case, the family case, and the matrimonial case. All the cases retain their individual integrity when they come to IDV court. So, the rules of law and rules of procedure that apply to each case when they're in the originating courts remain in place. So if the criminal defense attorney comes in and wants a copy of the family court petition, we're not doing that. The criminal accusatory instrument is public record, so the attorneys on the civil case do have the opportunity to review the accusatory instrument and find out what the criminal charges are. If there's evaluations ordered on a family court matter, those evaluations are, first of all, the litigants have to sign HIPAA releases for the court to obtain the information in most of those instances. And also, that information remains within the scope of the family court matter, or if it was ordered on the matrimonial matter. It's not disclosable on the criminal case unless the litigant specifically, gives permission. So that's really important. We've been very careful to avoid HIPAA. I can tell you that in Niagara County, we're lucky in Erie County. We have a lot of conference rooms so we can meet individually on cases. When I'm in Niagara County, we're in one big room and people are like, what happened on that case? And it's like, we're not going to disclose, and violate people's HIPAA rights on that. When you're in IDV, the criminal case is going to be completed first. It's really important for due process reasons. The court is not going to schedule, unless everybody consents, but the court's not going to schedule the resolution on the family court matter for a hearing prior to the completion of the criminal case. And the reasoning for that is that the testimony in the family court matter, if it proceeds first, can be used in the criminal matter. So we're very careful to not schedule it. A lot of people say, oh, the cases take forever. Well, that's the reason why. And if you think about it, if the cases were in the originating courts, what would happen is that the criminal case would keep going. The family court case is still going to want to know what's happening in the criminal, and you're going to have those same issues. So there's not going to be a resolution of the family court matter, at least through a hearing, without the criminal matter being resolved. So it's not something new that IDV is delaying this. It's actually protecting people's rights by not forcing those trials to go forward. Also, the one thing when I started in the Stone Age in city court back in the early 80s, the response to domestic violence was to send someone to an anger management program because that's what we thought was the way to address these cases. The research has shown that domestic violence is what? It's about power and control, right? Anger management is addressed, it's a DSM-6 diagnosis, and it's really based on someone who's mad at the world, who's mad at different people. They're not looking to control one person or a couple people, within their home or their scope. So there may be times where someone does have an anger problem, but if it is a domestic violence case, the response to domestic violence, if it's been determined after in the criminal disposition, the domestic violence program is the appropriate response. Sometimes you'll see it in the family court matter if you have a case where CPS indicates for domestic violence occurring in the presence of the children. There may be a request at that point for that parent to attend a domestic violence program in the context of the family court matter, even before the disposition on the criminal case. That's up to counsel, but it's going to help the family court matter progress. So, you know, there have been responses where, well, we're going to challenge the CPS finding, and, you know, counsel has every right to do that. But that's where you're going to see a referral being requested by the court in the context of a civil case, is usually when CPS has indicated against a parent or parents, and I'm going to talk about that a little bit later. Also, the orders of protection. When orders of protection are issued in a court, the originating order of protection is transferred to the IDV court. Now, the IDV court is in a unique position because it's the IDV court's jurisdiction that can actually modify the temporary order of protection that issued in the originating court. However, if there's a final order of protection in an originating court, it's only that originating court that has the ability to modify that order of protection. I've heard a lot of family court staff and even some judges sometimes think that they can modify the order of protection from the criminal court. And what would happen is you may have a criminal court case where there's an order of protection and there's no carve-out. If there's no carve-out, the family court does not have the authority to even issue, which includes the children, or it's a stay away from the household. Family court doesn't have the jurisdiction to modify that. There's a case that came out, Fourth Department in 2019, called People versus Smart. The order of protection, the court held that the order of protection issued in the criminal proceeding that barred all contact between the defendant and the child cannot be modified by a subsequent visitation order of family court or Supreme Court unless it is first modified or vacated in the criminal court. So if it's a final order of protection, you've got to go back to that originating criminal court if you don't have the carve-out. There's been a lot of education of the town and village court judges, and city courts, I think, for the most part, are asking the question, are there children involved in the case? And then, checking off the carve-out on the order of protection. But if you do have a situation, you got to go back to that originating court if it's a final order of protection. If it comes to IDV, IDV can modify those orders of protection that issued from the originating courts. And often what we're seeing is that, for the most part, in IDV, if you have a criminal case and a family offense, we're really ending up with one order of protection, at least during the pendency of the case. Doesn't mean the family offense petition is dismissed, it stays open, but it makes it easier for the litigants, for law enforcement, for everybody to understand what the parameters are. Before the cases come to IDV, you may have had a family offense that's a non-offensive conduct, and you've got a criminal where it's a stay away. Now you've got that conflict. IDV can resolve that, and we do when the case first comes in. Anybody have any questions about that? Okay. Also, the terms of the temporary order of protection can include the right to obtain personal property. So as counsel, you can ask the court to issue a carve-out for your client to be able to go. Often it's with a police escort or a third party to obtain their personal property. Children can also be included on orders of protection, even if there's not an endangering charge. There's a case called People versus Moon. It's the Fourth Department. And it's 4383rd, 1379, 4th Department, 2007, that you can add the members of the same household to an order of protection. And that's why you're seeing children often added to an order of protection, even on a temporary basis. And you can also.
Is this under 530.12 of the CPO?
Yes.
Okay.
Yes. And also, how about pets? Why do you think pets can be on the order of protection?
They're usually just on power.
Right, Ann, absolutely. It's a way of controlling the family, the children. It's really important. And I mentioned to Yvonne that this week happens to be National Pet Awareness, Animal Awareness Abuse Week, so that, we've seen how animal abuse, it can often start. The abuse in the household can often start or continue through the pets. And people who might want to leave with their children, that in the past there wasn't a place for them to go. Recently, Haven House received a grant, and they do have, I'm not exactly sure where the pets are. I think they can actually be with the family if they're in shelter at times. So there's been recognition of the importance of protecting the pets as well. Any questions about anything I'm talking about? Okay. Sometimes we hear, oh boy, we're in IDV. We could have gotten joint custody, but now we're in IDV because that's the policy of IDV. I just want to clarify, it's not a policy of IDV. It may be the court's interpretation of the case law. And the case law in the 4th Department says that when an order of protection is issued, that reflects the inability of the parents to co-parent. And it's a case-by-case analysis in IDV, but if you've got a history where there's been a lot of domestic violence, or there's been a number of orders of protection, it may very well be that you're not going to end up with joint custody in the case. There are circumstances, and it can always be argued before the judge, but it's really very important to understand the impact on children, which I'm going to get to very shortly. But I think that also when you get to IDV, maybe in family court, it appeared that there was maybe a little bit of conflict, but not enough. But family court doesn't have all the information. The criminal court doesn't have all the information. Once you get to IDV, there's so much more information, and the court has to address that information. So that's why, there's a lot more scrutiny. Ultimately, the standard is the best interests of the children. Another thing that can happen, and I understand it's a challenge for counsel, and it goes to what I just said, is that IDV gets a lot more information. So you may have had a temporary order in family court of unsupervised access, and now we've got a charge pending in IDV with strangulation, and maybe the kids were present. Now there's some other information that probably family court didn't have at the time, and that's being addressed. You may see at times that your temporary order could go from unsupervised access to supervised access. And as counsel, I can understand that can be very challenging. And I would just ask you to, be mindful of the fact that now there's a lot more information before the court that the court's considering if that does have to happen. Doesn't happen all the time, but once in a while it does. So does anybody have any questions on that? When we're talking about IDV having a lot more information, I want to talk with you about risk and lethality assessments. So several years ago, all of our DV and IDV judges were attending a lot of trainings on risk assessments. And we heard about the Jackie Campbell risk assessment that I think she started about 25 years ago. She was a nurse at Johns Hopkins, and she started doing some research, and it was intended to help domestic violence victims understand the risk of and the lethality issues that were going on. in their lives. And her research concluded that while victims of domestic violence may, be able to almost predict when there's going to be a reoffense, so many of them didn't understand the scope and the danger of what was continuing to happen. So they came up with evidence-based research that victim advocates were using, that police were using, that prosecutors were using to help victims of domestic violence. So we go to these trainings, the judges are getting this information. It's like, okay, well, what do we do with this now? So we came back and we started a local committee. And our local committee, Judge Rosa was here at the time. She was our supervising judge. And we sat down with some experts, national experts, and developed what is known as the Family Court Judicial Guide to Domestic Violence Risk Factors, and went through basically the Jackie Campbell factors and looked at them in the context of how could that be played out in the court. What do you think some of the lethality and risk factors are in domestic violence cases? Kind of have that information before you. We found that based on the research, strangulation is a key lethality, red flag for lethality. Someone's loss of employment in the context of a domestic violence case. Substance abuse or mental health. It's not the reason for the abuse, the research has shown. However, if there is the presence of mental health or substance abuse issues, it can certainly escalate someone's tendency to commit domestic violence. Also looking at the context. Somebody may come in and it may sound like an innocuous, they pushed me, and they come in on a family offense. What happens usually, the research has shown, is that once a victim of domestic violence gets to court, there's usually been a number of incidents that have happened in a real domestic violence case. And that one case that may kind of seem innocuous is actually just the tip of the iceberg. That there may have been a lot more going on in the past. And that's why it's so important to get the history. And that's what we do. In family court, we're required in every custody case to run a registry check. The registry check is of the domestic violence registry, of sex offender registry, of prior neglect history, and outstanding family court warrants. That's where we're seeing, where there's been prior family offense petitions filed, even when the orders of protection have been dismissed or withdrawn. We have that history. So it's showing something's going on with this family. Don't know exactly which way, but that's giving us some information. Also, the parties, have they been recently separated? The time of separation is probably one of the most dangerous times for a domestic violence victim. And that also includes the time when they're going through court proceedings, because that's a time of separation. And that can, increase the risk of lethality and recidivism. In those cases, what you may see is in family court, if there's a need to keep the parties apart, as I mentioned earlier, the court also has the ability to order temporary child support if that's necessary. Access to firearms, that's huge. Jackie Campbell's research has found that when someone has been threatened with the use of a gun in an intimate partner relationship, they're 20 times more likely to be murdered. So that's the research that's happened. So again, those are lethality factors, and that's why the courts are, definitely looking to ask on a continuing basis. Are there guns? Did somebody get the guns? You do your best. There's a lot of illegal weapons out there, we know that, but the courts are asking on the record, the judges are asking at the time of the issuance of the orders of protection and in sentencing, are there any weapons? And directing the immediate surrender of the weapons. Threats to kill, controlling jealousy, violent jealousy, repeated calls, texts, or emails, stalking behaviors. And also, as I said, the petitioner's belief that the respondent would reassault or attempt to kill them. The research has shown that, again, the victim may have a good sense of the reassault or the reoccurrence of violence, but many victims of domestic violence are seriously underestimating the conduct. Also,
Excuse me, Sheila, in the IDV, do you guys automatically set them up with a DV advocate?
they do. So in
Okay.
IDV court, there is an on-site victim advocate
Okay,
that people have access to. A lot of people come in and say, I don't want to talk to them,
right.
but there is an on-site victim advocate. City court also has victim advocates, and technically there's victim advocates assigned for every town and village court in Erie County.
There's also a new one from Haven House that's on the 4th floor of the
In
building.
family
In
court.
family court.
Yes, so family court has
Right.
on-site victim advocates
And
too.
I would counsel folks, the family court folks particularly, to be using those people because they understand how to create a safety plan for your client that you certainly I certainly wouldn't know what to tell them to do, but I think these folks will be able to tell them what to do.
Absolutely, and they can also assist if counsel's not involved in the case yet. They can also assist. They've been trained on how to assist with the preparation of the family offense petitions and getting into the history and explaining, to the court so that somebody doesn't come in and it seems just an innocuous type of situation. So yes, thank you, Yvonne. Also, if the perpetrator, has threatened to kill themselves, that's also, a lethality factor. Threats to harm the children, have the children witness the violence. These are all things that the courts are looking for in trying to fashion appropriate orders and orders of protection. So that's how we pulled in for the judges. What I found was what's in your packet is that the Center for Court Innovation, which helped us develop the Family Court Judicial Guide to Domestic Violence Risk Factors, which are now available. This is for judges all over New York State now. So we're pretty proud that we were able to get something that is helpful to the courts. But for your purposes, what I found is that the Center for Court Innovation had in some research suggested domestic violence risk guide for civil legal attorneys. So this really gives you the list of, again, the factors from the risk and lethality assessments and how you can pay attention when you're talking to your clients of what these factors are. For those of you who are representing defendants, again, these are factors that are important for you to know. These are things that the court's looking for. It's also important to understand that risk is not static. It's not dynamic. It changes over time. So maybe things are good, but by the time you come back to court, or maybe you hear from your client in between cases that all of a sudden something's happened. It's changing. So that's why whenever you come in for a pretrial, in IDV, we're asking what's going on with the family. Anything new? That's what we're looking to hear on the civil cases. Usually on the criminal cases, the complainant is speaking with the DA's office so that they can, relay that information, and it's up to the DA's office to relay the information to the court. So I think it's really, I would suggest that, you take a look at this guide. I think there's, while it says for civil legal attorneys, I think it's a really good synopsis of what the courts are looking at. Again, it's evidence-based research. So it's not just things that we've been thinking about. This is all evidence-based research. And again, it's permitting the courts to be more informed in making decisions going forward. Anybody have any questions on that? Okay. We've talked about the impact on children. there is evidence-based research. I think for so many of us who have practiced in family court for a while, we knew that there was something going on when children were exposed to domestic violence. I mean, we knew it in our gut, but now there is evidence-based research on the neurological impact on children's brain development when they're exposed to domestic violence. And it's a real risk. It's a very serious risk. In your materials is an article from the Judges Journal by Lynn Heck-Shafram that really gets into the details. And this was something, again, that we received at a training, the judges received at a training. But, you know, it's important. We started to bring this information back. And many of you have already received this article if you've been in IDV court. But it was like, okay, how are we going to get this information to the litigants? In the first paragraph of this information is a YouTube video, and I would like to show this to you now. Thank you, Nick. I think it's a synopsis of the research that is contained in that article, but it might be something that you want to consider reviewing with your clients as well. This was developed by the California State Attorney General's Office and is from Dr. Bruce Perry, who's an expert on children's development.
Because of the way the brain works, you will always remember your very first roller coaster ride. Storing these new experiences is one of the brain's main jobs. In fact, your brain creates a mental blueprint of every new experience you have. A blueprint for any new touch is stored in one part of the brain. A blueprint for any new sound in a different part. And a blueprint for any new sight in still another part. But as powerful as that first roller coaster ride was, it can't compete with the lingering effects of your brain's earliest experiences. Although you have no conscious memory of this part of your childhood, it is these very first experiences that literally become the building blocks for your whole life.
Unlike other organs, the brain is undeveloped at birth, and it is waiting for experiences to shape how it will develop. The amazing thing about the human brain is that the younger you are, the more sponge-like your brain is, which is the reason that children in 3 years can learn language, can learn to walk, can do all kinds of incredible things. But the very same biological sponginess that allows us to rapidly acquire language is also the same sponginess that makes young children more vulnerable to trauma than older children.
Well, we have the opportunity to do police ride-alongs to a domestic violence situation. So this was actually the first call I ever rode along. It was dinner time. They were having spaghetti for dinner. It was dripping down the walls. The kitchen table was overturned, and we had 3 children in the household. Looking at this whole situation at the time, we said, no evidence of physical harm, the kids are fine. We learned differently, of course. The boy in the corner was classic behavior that we see with kids who have had chronic exposure to violence. He would just completely zone out, numb out as things started to get scary. The 6-year-old little girl on the chair blames herself for what's going on. But actually, it was 4 years later that we really appreciated who had some of the most profound or severe harm coming out of this situation, and that was the 6-month-old baby who was now 4.5 and had seriously injured another child in preschool.
It's literally the opposite of the way most people think about this. Most people think young children, they don't really understand what's going on and they're resilient. But the fact is, if anybody's impacted more severely, it's the younger child.
The brain is put together like building blocks in a sense. Those first blocks that go together are the more primitive area, the survival brain.
The brain develops from the bottom to the top and from the inside out, so that the normal development of the top part of the brain depends upon healthy development of lower parts of the brain. The top part of the brain, where you do all of your thinking, is the part of the brain that is most changeable, easiest to modify. But unfortunately, if a child has developmental experiences of threat and exposure to domestic violence, the lower parts of the brain will be impacted and they're harder to change as they get older.
He was never physically abusive, but he was verbally abusive. There was lots and lots of screaming in front of the kids, berating, putting me down, and they pretty much heard it all.
Children exposed to domestic violence, children who witness their parents fighting, literally are experiencing a state of fear. And when this happens, the systems in your brain that are involved in thinking at the top part of your brain are literally shut down. It changes the brains of these children.
My son has seen and heard a lot of the violent outbursts. He was experiencing night terrors, and that was probably his way of dealing with it, because in his waking state, he didn't know how to articulate at 2.5 years old. So it was coming through, when he was asleep.
When kids are chronically stressed, one of the problems that we see is difficulty in attachment, in bonding, because they're so focused on survival. It's hard for them to reach out and connect with others.
My oldest boy went through a stage where he would bully his younger brother and seemingly laugh in glee. He was not remorseful or had no empathy that he could actually make someone cry. Many phone calls of him being disruptive in the classroom. He was a very bright kid, but that's when I knew that he was heading toward trouble.
A lot of these kids get labeled as being, bad, difficult, defiant. This is a very natural response to their circumstance. What the child is doing is a survival strategy for them, but it creates behaviors that are very difficult in the classroom. When they're in a crisis mode, they can't learn.
The tragic reality of children growing up in domestic violence is that they end up with mental health problems at a rate higher than children who are actually the direct victims of physical abuse.
My mother was a victim of domestic violence. My father was an alcoholic, a drug user, and it's just a cocktail for a bad living environment for children. My brother, he looked like he was crying on his way home. Me not knowing, I was just a careless little 6-year-old, seeing him climb up to my mom's medicine cabinet. I asked him what he was doing, and he boldly said, I'm killing myself. 8-year-olds don't talk like that. The first person I thought to call was my best friend's mom. By the time she came down to our apartment, he had a butcher knife in his hand. He was just cutting himself all over his body, and I was just bawling, just crying. There was nothing I could do to help. My brother was crying. He didn't want to be there. He was trying to run out. But I had already known that my home, wasn't my home. It wasn't a place where I felt safe.
Childhood exposure to violence is about living in a threatening, scary environment that may escalate to physical violence, but it often doesn't have to. It's the chaos, the uncertainty, the fear of being in a home where things aren't okay. Very interesting talking about the roller coaster, because that's what we hear from adult survivors who are in violent households and also the children. The hard part for them, I think, is thinking about what is normal instead of this up and down life of being in a violent, threatening relationship.
Growing up in my home, there were 6 children. My mother and father, unfortunately, fought like cats and dogs. As a result of that, 2 of my brothers ended up being batterers. I have 2 sisters. Even today, they date men that batter them.
Exposure to violence is a lifetime legacy. We see that adults who have had negative childhood experiences often have coping behaviors that can be unhealthy. That certainly has huge effects on how one is going to parent.
It's really important for parents to understand that their internal state, whether it's calm, or whether it's alert engagement, or whether it's frustration and anger, whether it's sadness, depression, the baby absorbs these internal states.
I have been in the moment with that sense of helplessness and hopelessness and stress and anxiety and rage. It really damages the brains of small children to be under a constant level of stress and anxiety. Every day I hope that I haven't damaged my kid in any way.
They need to see from you as a parent how to deal with stressful situations in an appropriate manner. Being rational, not resorting to violence to deal with situations. Your children are going to learn how to deal with stress from you.
Luckily, my older son is verbal enough and is old enough now that we have conversations about how did it make you feel when that was going on? Was that scary for you? Yeah, and validating that.
The biggest thing that helps children exposed to violence is to be able to talk about their feelings, get those critical messages. It's not your fault.
Any conflict, I'm able now to stop before I add to it. I'm able to step away rather than trying to solve it at that moment in a state of heightened anger.
Just try not to go through it alone. If you have a strong support system, and know what avenues you have available to you, in case you do need to get out. I was glad that we got help when we did.
One of the great things about brain science that we've learned is till the day you die, you have the ability to add new neurons in your brain, that the brain is more like skin in the sense that it can rewire and heal itself in the most important area, the cortex. We have the capacity to heal and do better. The biggest thing we can do for kids exposed to violence is how many healthy adults can they connect to.
I did a lot of my childhood in other people's homes, so I saw what positive relationships were about. I saw my friends were normal, they didn't have the rage I had. Seeing parents that were together, that showed affection. Home dinners where everybody sat together. Those are the things that I realized were important. And instead of being envious, I incorporated it into my life. I wanted to be a part of that.
I know school is what made a difference for me. The teachers, the attention I got, letting me know that I could be somebody and I could do something.
In fact, my oldest son, his teachers, all 6 of them were very instrumental in coming forward and providing him support when he needed. They allowed him to be homeschooled to give him time to heal.
The hardest part about being a parent now is trying to be different than how my parents raised me. Am I being a good father? What do I need to do to help you feel safe in your home?
That's the part, the brain development part, that I think we want him to know what normal is for us. And normal is having people who support you and who love you and who want to take care of you. And that we want that to be his normal life.
It's one of those pay me now or pay me later. And the truth is, children who are good at self-regulation, good at self-soothing, don't cry very much, and end up being, if you will, successful, are children who have had incredibly attentive early caregiving, which some people, unfortunately, think of as spoiling. It's exactly the opposite. Rather than spoiling the newborn, what you're doing is you are building in healthy self-regulation.
So those are the things that I want to create an environment for my baby where he gets the benefit of what I've learned from all these experts and also other parents. And believe me, they're experts too.
The most important thing that parents need to understand is that the brain of their child will become exactly what the child was exposed to. If you want your child to be kind, then you have to be kind to your child. If you want your child to be good at self-regulation and not lose their temper, you have to not lose your temper. And that's the beauty of the human brain. It is a mirror to the child's developmental experience.
Thank you for your attention to that video. Some of you may have seen that before, but this was a synopsis of all of this evidence-based research that we were getting at court trainings. And we brought it back and we're trying to educate. We started with the bar, but it was like, and I'm sure so many of you know that the litigants will come in and they don't know this, nor should they be expected to know. We didn't know it until somebody presented it to us. So we were trying to figure out how are we going to get this information so the litigants understand this information. Haven House, Victim Service Agency in Erie County, was thinking about this issue at the same time. And they developed a program called Parenting After Violence. We sat down with them and we asked them, you know, this information's out here, it's evidence-based, you know, it's not to punish a victim of domestic violence, but how can we bring this information to a victim of domestic violence so that they can make more informed choices going forward? And they developed this Parenting After Violence program, which has been incorporated into their domestic violence training. And Haven House was kind enough to do a train the trainer for all the victim service agencies in the 8th Judicial District. So I'm happy to say that almost every county has a program similar or has this information being disseminated to the domestic violence victims. We also sat down with Catholic Charities Domestic Violence Program and asked them to incorporate this information into the domestic violence program. Both the Parenting After Violence and the Catholic Charities Domestic Violence Program show this video. I think it's very effective because it ends up positive. You know, it's not just pointing fingers, but it's really indicating to parents exactly what's going on. And this is the reason that children are included on orders of protection on this type of situation, knowing that there is, you know, neurological damage that can be done to a child. Doesn't mean there can't be a carve out, and it doesn't mean that there's not therapies that we're looking at to put in place. As a matter of fact, we also reached out to local providers. Best Self has a lot of trauma-informed counselors for children. And if anyone's ever worked with Annie Monaco, she's someone who does a lot of the trauma-specific training. One of the things, I saw her at a presentation, and she talked about a little one who was in school, and the child was being labeled and was going to be put into special education. The child was picking up desks and throwing them across the room. Found out the background was it wasn't ADHD, it was exposure to violence in the home. With the counting therapies, with the child-specific therapies that they've developed on trauma, Annie has been doing this a lot, and she said that when they get children in, there's often maybe 3 months of intensive training. They're undoing the damage that's been done to the brain for a child. That was some of the most important information I've heard since I've been doing work in domestic violence cases, you know, for over, 30 years. That was one of the most hopeful things, that you can actually undo that damage with the children. But then we were thinking, well, what about the adults? Because children's brains are developing till roughly around age 25, it's a lot easier to change that for a child, but there's still trauma counseling that can be for parents. And it can be for not only the victims of domestic violence, but the defendants as well. There's a program that's being developed right now in Erie County. It's going to be piloted, called Caring Dads. It's not going to be in place of the domestic violence batterers programs, but it's really going to get into much more detail. And it's going to talk about trauma and give resources for the parents, for the offenders to also have some trauma therapy. So again, this is why we're including children on orders of protection. And also law enforcement has had a lot of education on this issue. So you're seeing more charges of endangering the welfare of a child, and that's almost going to be always, the child's going to be on the order of protection when you see that. Again, doesn't mean it can't be argued not to, but that is the basis when you do see the court put the children on the orders of protection. Yvonne mentioned the role of the victim advocates. That was one of the last pieces. And I also want to note there's this lawyer's manual on domestic violence. I'm gonna leave a copy of it here, it's in its 6th edition. It was actually prepared by the New York State Judicial Committee on Women in the Courts. It's got a lot of really good information in it. I'll leave the link because it's also online, but I want to end just by saying thank you so much for the opportunity to speak with you. Thank you for your willingness to be considered to be on the IDV panel. It's a lot of hard work, but I can tell you that, continuing the work that you've all been doing, it really does make a difference in people's lives so that they can have a chance in the future. So thank you very much.
Thank you,
Judge.
Thanks.
Thank you.
5-minute recess and then we'll resume. That works for everybody?
Sure.
Thanks.
Sorry, it went over.
That's okay.
Very good. Yes. Oh, yeah, there it is. 160
We're good? All right, welcome back, everybody. Why don't we resume?
Yeah.
And, thanks again to Sheila for her presentation. I think it was very informative. If nothing else, I think it gives you some insight into the level of knowledge and training that the judges and court personnel and prosecutors have when it comes to handling matters that appear in IDV court. And the code there that you see now is for the folks who are watching in TV land, so if they want to get credit, I guess they have to provide that information. But anyway, what I'm going to talk about for a little while are the rules of evidence as they pertain to domestic violence cases, cases of child abuse, and sex offense. Now, I don't mean to suggest for a moment that there are different rules of evidence or that the rules of evidence are different in IDV court or a DV court, as the case might be, from any other generic type prosecution where, for example, the victim and the defendant are unknown to each other. But where there is a significant difference, I have noticed based on a few years of experience as a domestic violence judge, both in city court and county court, handling some of these cases as a prosecutor, and from just reading a lot of cases. What I've noticed is that there's a difference in the way the rules of evidence are applied and interpreted by the courts. And by that I mean they're generally interpreted in a way that by and large favors admissibility over exclusion. And this is particularly true in the areas of Molyneux evidence, for example, where the people are seeking in their case in chief to introduce evidence of the defendant's prior bad acts or uncharged crimes, not to prove that the defendant is of a criminal bent or predisposition, because the law says you can't do that. That's improper character evidence. But, for example, to prove things like motive, intent, identity, absence of mistake, common scheme or plan, or common themes that you'll hear in DV cases. Your Honor, we are offering this evidence to show the nature and background of the relationship between the parties, or to explain, for example, why an order of protection has been issued. So that's one area of law where the case law is replete with examples of prior bad act evidence, which can be pretty damaging to the defense. It's admitted with regularity and frequency. Okay. Another example is on the flip side of Molyneux, which is Sandoval, where the prosecution seeks to introduce the defendant's prior bad acts or convictions not as substantive evidence, but rather to impeach his credibility by showing that he's placed his own self-interest over the interests of society, or is an otherwise disreputable person who's not worthy of belief. So that's another area. Also in the area of hearsay, there are so many different avenues of admissibility in any case, but in particular in these kinds of cases that we're talking about. All right. So, for example, excited utterance are a common vehicle for introduction of hearsay testimony or present sense impressions. Also, introduction of statements in hospital records for purposes of diagnosis and treatment, which will include not just what the injury is, but how it happened and who did it, which is pretty damning information to have in a hospital record. But the way the courts have been, and we'll get to it, but the way the courts have interpreted it is that, well, DV is part of the diagnosis, and the treatment includes developing a safety plan for the victim. So the nature of the abuse, the fact that there was abuse, and the person who did it as a boyfriend, husband, or significant other is relevant and deemed to be admissible. So that's an example in the hearsay field where the courts are pretty, shall we say, receptive to that kind of information. And if it's not admissible for its truth, there are avenues of admissibility for non-hearsay purposes. For example, evidence of a prompt outcry in a rape case. Not the details, but the fact that there was a prompt complaint to rebut claims that the victims didn't report in a timely manner, for example, to attack their credibility. Or in cases of child abuse, you may have a situation where the hearsay, the child's complaint about what happened to him or her, is admissible not for the fact that it happened, but to explain how the police investigation began and how it progressed and found its way to the defendant. So the courts have many different avenues by which they permit this kind of damaging testimony to the defendant, that is, to be admitted into evidence. This is probably no revelation to any of you, but another area where the courts tend to favor admissibility is in expert testimony. Not to prove necessarily that the defendant committed the act of abuse or that the victim necessarily was abused, but to explain certain behaviors of victims who suffer from certain syndromes, such as rape trauma syndrome, child abuse syndrome, child abuse accommodation syndrome, or battered wife syndrome. So experts are frequently permitted to testify in generalities about some of the behavioral characteristics associated with these victim syndromes, if you will, to educate the jury, to dispel certain myths and misconceptions about human behavior and what people think about how a victim should behave, and also to kind of repair the credibility of the victim, who will not will clearly come under attack for, well, why didn't you report it? Why did you stay with the guy? Why did you change your story? Why did you lie about it? Those are factors which in a non-DV type case or in a generic case could well be grounds for reasonable doubt and an acquittal in no time, right? But in these cases, experts are permitted to educate the jury along the lines that I just mentioned. Earlier this week, Harvey Weinstein, as you know, was convicted of criminal sex act in the first degree, which is a B felony, and rape in the third degree. He was acquitted of the crime that could have put him in jail for life, which would be predatory sex act. And in that case, the court admitted Molyneux testimony from actress Annabella Sciorra, I think her name is. She testified about being raped by him 26 years ago in her apartment. And that almost became a trial within a trial, because she was cross-examined about the fact that she didn't report it. She continued to stay in contact with this guy and so on. But in any event, he was acquitted of that particular crime. But the two victims who testified continued to have contact with Harvey Weinstein after the fact of the rapes. One of them maintained a friendly relationship with him, even though she changed her phone number after the fact. She gave him the new phone number. The other victim continued to have a sexual relationship with him after the fact. Now, if you're the prosecutor and you're looking at this case, you're probably thinking to yourself, how on earth am I going to get a jury to find this witness to be credible? Who's going to believe somebody who continued to have a consensual sexual relationship with somebody who raped them? That's why they called an expert witness. This was the same witness who testified in the Bill Cosby case. I think her name is Barbara Ziv, Z-I-V. And she had never met the victims, didn't listen to the opening statements. Her purpose, and to good avail for the prosecution, was to educate the jury, first of all, to explain to them first that rape is something that is more commonly occurring between people who know each other and are familiar with one another as opposed to strangers, which oftentimes people think is the norm for those kinds of cases. Also to explain the dynamics of rape trauma syndrome. Why, for example, a victim might not report the crime, especially when the crime was committed by someone who exercises, you heard the phrase before, power and control, in this case, over their career, right? And why would someone continue to have a sexual relationship with someone whom they claim forcibly raped them? So this expert was allowed to testify, as is often the case in these matters, to educate the jury, to dispel misconceptions, and also to repair the credibility of the witnesses who clearly came under attack for those very reasons. But these are precisely the kind of factors that would, at least up until this point, would give prosecutors pause and say, do I really want to try and take this case to a jury? But now, in the generation of Me Too, which I think Harvey Weinstein was responsible for ushering in large measure, jurors are becoming much more savvy. They're being much more educated and disabused of a lot of the myths and misconceptions about how people behave when they're victims of these kinds of crimes. So and the prosecutor, the chief, the head of the office, Cy Vance, did a press conference basically saying this is a new day in the area of sex offense prosecutions. We've ushered in a new landscape, a new era, where people are going to start to think differently about these kinds of cases brought against violent sexual predators who manipulate, who coerce, who sexually abuse, and then try and threaten people not to come forward. Like, you'll never work again in this town, or what happened between us stays between us, if you understand what I'm talking about, kind of thing. And I think, or at least I suspect, that prosecutors will be a little bit more confident taking cases to trial than they might have not otherwise have done before. I suspect that victims will be somewhat or feel somewhat more empowered, that at least maybe I'll be believed now. But I think beyond that this creates a significant challenge for defense attorneys, because these are difficult cases to defend in any event. Just the mere fact of the accusation puts people off, makes people uncomfortable. So I just think it's going to make your job all the more difficult. And so I think defense attorneys have to start thinking about how are we going to go about defending these difficult cases? Are we going to use the same old strategies that we've been using, that some people will now call or refer to as victim blaming, victim shaming, re-victimizing the victim, that kind of thing? I mean, obviously, credibility is always key in these cases, but is it going to be enough just to show that the victim didn't report it, or that the victim changed her story, or stayed with the guy, or are you going to need something more? I'm of the firm belief that an expert witness for begets an expert witness against. Just think of personal injury cases. Have you ever heard of a PI case, let's say an auto accident case, where the issue is serious injury and some plaintiff's claiming I got a spinal injury, and they call an expert to say, well, it's causally related to this accident. Well, you're darn well tootin' for sure going to know that the defense is going to call a so-called IME to say, no, I examined this plaintiff and I find that his or her injuries are the result of degenerative disc disease, not at all related to this accident, right? So you can bet that in many of these cases, and maybe more of these cases, prosecutors will be calling these expert witnesses to explain the victim behaviors so that the jury can understand it rather than dismiss it, right, out of hand. So first of all, jury selection, I think, will be more important. You really have to think about what kind of jurors you're going to want to listen to a case like this. But also, is there an expert that you can call? Alicia, Lily, and I were talking earlier about expert testimony on the issue of traumatic memory distortion as a result of some type of traumatic event, whether it's the result of having been raped, a one-time situation, or being the victim of long-term abuse, or perhaps somebody who's been in the military and subjected to repetitive trauma and stress. And the experts in the field talk about how the memory over time after trauma tends to fill in the blanks with made-up details. Not because the person is necessarily lying, but it's a coping survival mechanism, and I'm not going to get into the science of it at this point, but it's something to think about as a way to maybe counteract some of the expert testimony that you're likely to get from the prosecutors, which can be pretty compelling, right? In appropriate cases, you may want to think about that. Sheila was talking about victim advocates, and I think they perform a most important function for the victims, just shepherding them through the process. But I wonder how much influence they might exert over the victims in terms of the stories they tell. And that's something that you may want to be thinking about, the power of suggestion and how that can impact upon the story that someone tells. When you think about, one of the most prominent recent examples of how memory can be distorted and embellished as a result of a traumatic experience is what happened to Brian Williams. Very respected news reporter, right? He was the main anchor on, I guess it was NBC News. He's now been relegated to the 11 o'clock slot on MSNBC because he was, embarrassed by the fact. What he did was he recounted a story where he was in country, so to speak, and he said, we were in a helicopter and our copter came under direct fire, rocket launching fire, whatever it was. As it turns out, he wasn't in a helicopter that took on fire. It was the one that he was following. So the question is, was he purposefully lying about that to just sound like he was in danger and make it a more dramatic story? But why would he do that if he knew it could be easily refuted? So some of these experts and scientists are saying this was not him purposely lying about what happened, but rather that it was his brain filling in the details. And he may have actually believed it. Whether you accept that or not, I don't know. I mean, Hillary Clinton kind of did something similar when she said, I came under fire when, there were bullets flying by us when we were in Bosnia. And I said, no, that never happened. Now, was she lying? Maybe. Or others would attribute it to this confabulation or the memory playing tricks as a result of trauma over time by filling the details. My point simply is this, that as you're preparing these kinds of difficult cases for trial, if you know it's going to trial, to me, it's not enough that you understand the law of your case and the rules of evidence, which we'll talk about a little bit, but you need to understand the psychology and the science that's involved in your case. And Alicia here is our new forensic liaison specialist, and she can link you up with experts because I don't think it's going to be enough just to do the traditional tried and not so true approaches to attacking credibility if you want to be successful in these cases. So something to think about as you're preparing these cases for trial. But not only do you have to know about the dynamics and the science of it, but the nature of these cases and the people who are involved, the offenders, the victims, the complexity of their relationships, and you better know what the judges know. I'm glad that Sheila gave us a little peek into what goes on with the judges, and I know from my own experience about the training. I would dare say that the training borders on indoctrination. And I'm not saying what they're being told is false or wrong by any means. But my point is, the judges believe it. And you need to know that. Okay? That when you're talking about domestic violence, you're not talking about random acts of violence here. You're talking about purposeful, directed behavior, violent, coercive behavior directed by one person against another for one purpose and one purpose only. Power and control. You heard Sheila say it. That is the mantra that pretty much dictates every judicial decision in domestic violence court, which is power and control, but victim safety and offender accountability. You need to know that going in if you didn't know it already. So in terms of why the courts tend to be more generous when it comes to this type of evidence, whether it's Malino, hearsay, expert testimony, it's because, as I indicated, the judges have learned and they generally accept the premise that these cases are different from the rest because of the nature of the relationships and that they view DV as purposeful patterns of assaultive, coercive, and manipulative behaviors that work on multiple levels, whether it's physical, psychological, emotional, financial, sexual, and it's all about this notion of power and control. Now I'm going to fast forward a bunch here, and I'll come back, because I reorganized my thoughts after the verdict in the Harvey Weinstein case. And that was after I'd already put this down. So if you're doing a DV case, you got to understand the mentality, the thinking, what drives the judge's decision making. Okay, and as many of you probably already know, that the main model that most judges follow in analyzing a DV situation is the so-called Duluth model, which originated in Duluth, Minnesota, and it views domestic violence as a pattern of purposeful behaviors against the spouse or significant other, including a variety of strategies and behaviors: isolation, intimidation, emotional manipulation, financial limitation, domestic incarceration, meaning you're limiting the victim's ability to come and go, you control her comings and goings, physical violence, minimization. In other words, what are you talking about? What are you making such a big deal about it? Kind of thing. Prevarication, meaning lying. No, I didn't do that. You're crazy. And then there may be that temporary period of contrition. You know, I'm really sorry for what I did. I'll never do it again. I'll get better. And the next thing you know, it happens all over again. But the thinking behind this model is that the purpose is power and control. Keep that in your head. You'll understand where the judge is coming from, what the judge believes to be so. Does your client have the presumption of innocence in DV court? I hope so. But the judges are wary, especially because if the defendant has a prior criminal history or a history of domestic violence, orders of protection, you can bet they're looking at him, and I say him because it's mostly him, with a jaundiced eye. He's likely to do it again because domestic violence offenders are like lepers. They don't change their spots. You can control it maybe, but you ain't going to change it. Now, ideally, they would come around. So the model is not, remember Sheila mentioned the phrase accountability. They're not rehabilitation courts. They're not. They're accountability courts. Keep the defendant under the court's watchful eye. So when they send them to these programs, such as batterer's intervention, it's not to cure them, because studies have shown that they don't keep recidivism down for this kind of behavior, but rather they want to educate the offender as to the nature and consequences of his violent ways and to deter future violent conduct. How do they do that? Well, maybe for a period of incarceration, protracted period of probation, what do they call it? Compliance court, where you got to keep coming back just to make sure that the judge is still watching. The analogy that I once heard was, it's sort of like when you're driving down the highway and you know that there's a cop behind the next tree, you're less likely to speed than if you don't. So that's kind of the role of the judge there, to sort of keep the peace and keep an eye on you, or meaning as the defendant. And battered wife syndrome, it's something, if you don't already know about, you should become aware of, and become aware of all the elements of child sex abuse accommodation syndrome or child sex abuse victim syndrome, because if you're going to handle these cases, you're likely to be dealing with an expert who's going to testify and educate the jury about these things. So you have to understand the dynamics of DV and the symptoms of survival strategies of victims. So, for example, with battered wife, and I'm not going to spend too much time on it, but just so you get I just use this as an example, one area where you're likely to encounter an expert witness. Where a defendant, for example, engages in patterns of isolating the victim from family and loved ones, and tension is building in the relationship. He may keep her under control with verbal criticism, raised eyebrow, or raised hand, may beat her down verbally, make her feel uncomfortable, less than worthy. And then there are episodes of physical violence of one form or another. Then you have that period, honey, I'm really sorry, I was drinking, or you just make me so crazy, and I'm just so jealous, I love you so much, please forgive me, I'll get better. And then boom, it happens all over again. And then they also talk about the so-called power and control wheel, or wheel of misfortune, depending on who you are in the process. I remember when I was DV judge in city court, I went to a batterer's intervention session just to see what goes on. And you had a bunch of guys sitting in a circle, none of whom appeared to be too thrilled about being there. And they had this woman who was probably in her 60s, a very intelligent person, schoolmarmish kind of woman, talking to the guys about the power and control wheel and educating them about the components of it, how you guys are using strategies to, do you understand what you're doing here and how it affects your significant other, whether it's physical, sexual violence, emotional abuse, how you've isolated her, or you're minimizing what you've done, or limiting her ability to spend money or to participate in decisions, and so on and so forth. And one guy raised his hand, but she invited me over to the house, and then the cops were waiting for me, kind of thing. But this is the thinking, and so when they go to these programs, that's what they're getting. We're going to tell you about you, so that you know that we know, and the judge knows, right? And that's the reality. And incidentally, when it comes to bail, and the bail rules are a little bit more strict for cases of domestic violence and sex offense than they are for other offenses. So those are two of the offenses which almost always are considered to be qualifying offenses for which monetary bail can be set. All right? But what a court can do as a condition of bail, whether it's OR or non-monetary conditions or whatever the case might be, the court can also, as you know, impose an order, temporary order of protection. But say as a condition of that order, I'm going to require that you attend batterer's intervention counseling. Now, batterer's intervention counseling, again, it's not rehabilitative, it's educational. And I remember when I was going to one of these programs, I said, well, how do you reconcile that with the presumption of innocence? If you're calling it batterer's intervention, defendant comes in and goes into the program and say, hey, my name is Fred, I'm a batterer. Because they want you to acknowledge who you are and what you are. But the courts have basically said, this is an educational piece. And if it alerts him to what's required of him, and he's more likely to abide by an order of protection, which has been issued as a condition of bail, it's proper. I've cited some cases in my material that you're welcome to read. People versus Soto is in there, People versus Bon Giovanni. So the courts can do it, and many courts do, as part of bail. And then the effects of domestic violence on the victim, typically living in fear, always looking over her shoulder, trying to develop strategies to make it stop. What can I do to get him to stop beating me up, kind of thing? And if those strategies don't work, then the victim starts to feel like, there's nothing I can do. It's hopeless, so therefore I am helpless. And so experts might be likely to talk about the so-called learned helplessness, where someone is on an invisible leash. And the expert may use that example and let the jury conclude or understand why she didn't leave the guy. Okay? They're not allowed, however, to testify that this victim was abused or that he did it. But, the jury can do the math, right? If the victim says, this has been my life, this is how I've been behaving, I say he assaulted me or raped me, and then the expert comes up and gives all the symptoms of a battered spouse, what do you need the expert to tell you that she's a battered spouse? They can do the math for themselves. That's why I think it's so important for you to consider countering expert testimony with expert testimony whenever possible. So now let's go back. And I'm not going to go, and I've got way too much information that I could possibly cover in an hour. You can read that at your leisure. But I just want to hit a few highlights so that you're mindful of them. One of the points I wanted to make was that when you look at the court decisions, they often incorporate this language, this domestic violence language, in their decisions. I'll give you a couple examples. People versus Westerling, which is up on the screen there. It was a Molyneux situation where the court said that prior bad acts in DV situations are more likely to be considered relevant and probative evidence, usually of motive or intent. What's the motive? Power and control. Because the aggression and bad acts are focused on a particular person. I'd be willing to bet that the judge who wrote that decision went to one of these seminars and has been educated on what domestic violence is all about. So if the judges are educated, prosecutors are educated, you have to be able to adequately and effectively represent your client. People versus Birnbaum was an interesting case. It was a murder case, domestic violence murder, where husband and wife had kind of a tumultuous relationship, and she was threatened. They were getting ready to have a divorce, and she was saying, if you don't give me what I want, I'm going to expose you to your colleagues, let them know what a piece of shit you are. And she actually had a letter from a psychiatrist describing some of his violent behaviors and so on and so forth. Next thing you know, she ends up sliced and diced in a suitcase that ended up being dropped out of a plane somewhere between Jersey and New York. And so he ends up getting indicted for it, and the court permitted the introduction into evidence of statements that the wife had made to family members and friends, saying that she was afraid of him, he's threatening me, he choked me in the past. And the court kind of glossed over the hearsay issue, just saying, well, these were spontaneous statements, so they must have been reliable. But there's really no such hearsay exception of which I am aware. But be that as it may, circumstantial evidence case, pretty much not much other proof, and the court admitted such testimony. But the point is, the court went on to say that in a DV homicide, it is highly probative that a couple's marriage was strife-ridden. So that was on the Molyneux issue. And on the bail case that I mentioned, the People versus Bon Giovanni, which is, I think, on the 26th page of the screen here, the court went on to say, more women are hurt from being beaten than are injured in car accidents, muggings, and rapes combined. During the pendency of the case, the complainant's security is the responsibility of the court, and the court has the authority to take steps to ensure the defendant's compliance with conditions. And by the way, in domestic violence cases, that is the one area in which courts can consider victims' safety in setting bail. In every other situation, it's all about what can we do to maximize the likelihood he's coming back to court. But if you look at CPL 530.10, I think it's subdivision G, it'll say the court, if it's a family offense under CPL 530.11, the court can and should consider whether or not there's ever been a violation of an order of protection before, or whether what is his history and use of possession and use of a weapon. So that's the one category where a court can consider safety of the victim in setting bail. And as Sheila mentioned, even when a domestic violence victim is a defendant, they're entitled to try and have a mitigated sentence because of the fact that they're a DV victim upon whom domestic violence played a substantial role in their conduct. One thing to keep in mind, though, when courts are making decisions on Malino, and believe me, they're going to be pretty. The floodgates are pretty much open when it comes to Malino, by and large. You just have to accept that as a fact of life. You try and minimize the damage, but just because something is relevant, prior bad act or uncharged crime is relevant to intent, motive, or whatever the case might be, it's got to be an admissible form. It's analogous to summary judgment in a civil case. If you're going to bring a motion for summary judgment or try to respond to it, you have to do so with evidence in admissible form. So just because Malino evidence is relevant to one of those issues, if it's not an admissible form, it can't and shouldn't come in. In this Meadow case that I've cited there from the 4th Department, that was another homicide case. Circumstantial evidence where the victim was found on her kitchen floor, bound, gagged, and strangled. The trial court admitted testimony from I think it was her sister, where she said he's assaulted me in the past. The court said, well, that's hearsay. There's no exception that you've cited. It shouldn't have come in. Likewise with People versus Brooks, about a victim that talked about a prior threat that the defendant had made to her. And the court went on to say there's no blanket hearsay exception providing for use of hearsay as background in a domestic violence relationship. Background evidence is undoubtedly relevant or in a domestic violence case, but it's got to be in admissible form. You'll note under People versus Wolf, I said the 9th Department. Subtract 5. It was the 4th Department case. I just had a typo there. Sorry. This is what I call too much information that's difficult to read. Interesting case on identification, People versus Gina. This was a domestic violence case where the defendant had pretty much tortured his wife. He was out with another woman, comes home, sees his wife, and accuses her of infidelity, ironically. They get into an argument. A fight ensues, and then he ties her up and basically tortures her physically and sexually in a very specific way. And so we're talking husband and wife. They knew each other, right? Well, the defense is that she was not a credible witness, that she made it up. Defendant actually testified. His story was, yeah, I was out for a while. I came back home. We got into an argument. But that was the long and the short of it. I didn't assault her. And they said, well, what about all these injuries? Did she do it to herself? And he goes, well, she's a pretty angry person. I don't know why the guy testified, but be that as it may, the court admitted in the People's case in chief testimony from the guy's ex-wife, who he pretty much did the same thing to 18 months earlier, on the theory that it was relevant to the defendant's identity. And the defense said, wait a minute. Identity is not an issue in this case. They know each other. They're husband and wife. He admitted that he was there. He just denied that he committed the assaultive acts. Court of Appeals said, in reversing the appellate division, well, the issue in question is his identity as the perpetrator of the crime, not as the identity of someone who's just there or someone that she knows. And in denying the crime and suggesting that she was lying about it, and she being the only witness, he put into issue his identity as the perpetrator, thereby permitting or allowing into evidence similar acts that he had committed against his ex-wife. And there was a kind of a blistering dissent. The court said, does that mean every time a defendant denies committing the crime, therefore ID evidence, Malino should come in on an ID theory? But nevertheless, that's just something to be aware of. And we'll move along here. And this is for the folks in TV land. Is that good, Nick?
There's 3 of them, Judge, so make sure.
Okay.
If you skip slides, just make sure you go forward and get
Got it, thanks. Cortez is an interesting case, too. In this was a domestic homicide. Well, not so much domestic, but it was the guy killed his would-be girlfriend in her apartment. She kept turning him down. so he went to her apartment and he stabbed her. And admitted into evidence was a journal which included his ruminations and complaints about how this victim was giving him a hard time, which was deemed to be relevant to the issue of motive. But the court also allowed into evidence journal entries from 3 to 6 years ago where he was complaining about other women who he described as poisonous, and he was vowing to get revenge against them. And he described himself as a monster at one point. And the court said it was error to allow that testimony in because all it really showed was this guy was a screwed up, twisted misogynist. It didn't show that therefore he had the intent to kill this woman or prove that his identity is the perpetrator. But the court said it was pretty much harmless because there was a slew of other evidence, including his bloody fingerprint at the victim's apartment. But this kind of took Molyneux into the area, it expanded it to talk about someone's bad thoughts as opposed to prior bad acts. Whenever you find yourself in a Molyneux situation, these are the steps that the court must go through. Make sure that it happens this way. Otherwise, there's potential error there. The proponent of the evidence, i.e. the people, they have to identify for the court the non-propensity purpose for which the evidence is being offered. Then the court has to do a balancing act. What is its probative value versus the substantial prejudice, that being that the jury is likely to consider this evidence as propensity proof rather than evidence of intent, motive. And quite honestly, I've always wondered whether or not jurors can make these fine-line mental distinctions. When a court says, now, that prior act of sexual abuse that you just heard about, in this sexual abuse case, you cannot consider that as evidence that this defendant is of a particular bent or that he's predisposed to commit child sex abuse. You can only consider to the extent that you find that it identifies him as the perpetrator or it shows his intent in this case. I think once the jury hears that kind of proof, game over. Be that as it may, if a court gives its cautionary instruction, the appellate courts assume that the jurors followed it. But the court has to follow the steps then. That it's got to ask the proponent, what are you offering this for? And then the court has to balance prejudice versus probative value. Is there a need for this evidence? Is there strong evidence on the point already, such that if you admit prior bad acts, you're just piling on and running greater risk that the jury's going to be distracted? Or consider it as probative of a predisposition. And then you have to make sure, though, that you request a limiting instruction. Otherwise, you may waive it, that issue for appeal. So if the court doesn't give a limiting instruction to the jury and you didn't ask for it and you complain on appeal, you may find yourself SOL. These are just more cases that you can read at your leisure. We pretty much already talked about Sandoval, or at least I mentioned it. But when you have a client who has a criminal record, and there's a good chance you'll get a few of those, and you are pretty confident that he needs to testify, and you want to have a hearing on all prior bad acts and convictions that you're concerned the prosecution might inquire about on cross. And the court has to make a ruling, and you have to point out why these matters should not be looked into on cross-examination, again, because the probative value is substantially outweighed by its prejudice, i.e. in causing the jury to think that this guy's a criminal, or in chilling his desire to testify, such that he won't testify now because of the court's rulings. Crimes of dishonesty are almost always fair game for cross. Crimes of moral turpitude or calculated violence, or common phrase, placing one's self-interest over the interests of society. And don't think that just because a prior crime is similar to the one at bar, that the judges aren't going to let it in, especially in a sex offense or DV case. There's a case, People versus Hayes, where a defendant tracked down his wife in a motel room where she was hiding out. It was a true domestic violence situation. And trial court admitted It was so, and it was his word. His defense was this was consensual, by the way, and it was literally a he said, she said kind of a case. And the trial court allowed in evidence of his prior convictions for assault, sex abuse, and aggravated sexual assault to impeach his credibility. That's pretty damning stuff in a case where he's accused of sexual assault of his wife. And the court said that insofar as these convictions revealed his willingness to favor self-interest over that of others, it goes to the heart of honesty and integrity. And their similarity to the charges at trial should not preclude admission in the sound exercise of judicial discretion. I mentioned earlier that there are different avenues of admissibility, whether it's for a truth purpose or a non-truth purpose. These cases that I have here outline some of those. Because of our time constraints, and I'd like to get Dean up here very shortly, I'm going to just skim over some of this stuff, but you have it in hard copy, so these are things that you can have as a resource. So if you have a case where excited utterance come into play, or present sense impressions, or admission of a party opponent, or whatever, or statements for diagnosis and treatment, you can find them here. I think if nothing else, they'd be a good starting point. I'll just quickly mention this case. It's a fairly recent case from the Court of Appeals, admission by silence, People versus Vining. This was a DV case where the defendant, as is not entirely uncommon in these types of cases, calls his wife from the holding center or wherever he was being held up at the time. Hey baby, could you drop the charges? And so they're having a conversation, and she said, well, you broke my rib. And he said, so what, am I a threat to you? You gonna let me go to jail for a year? You don't care. The court admitted that conversation and said it was tantamount to an admission by silence by not denying her accusation. So if he hears it, understands it, is in a position to refute it, but doesn't, it's an admission by silence. Statements for diagnosis and treatment have been expanded in the DV context. I'll quote to you from People versus Benston, 2010 case from the Court of Appeals, which is right there. And in that case, the court allowed in statements of the victim that she was a victim of domestic violence, and she named her boyfriend as the person who's been abusing her. Here's what the court said, and again, this goes back to my earlier point of how courts are revealing their knowledge base in their decisions. With all that has been learned about the scourge of DV in recent decades, we now know that it differs materially both as an offense and a diagnosis from other types of assault in its effect on the victim and in the resulting treatment. In addition to physical injuries, a DV victim may have a host of other issues to confront, including psychological trauma issues that are appropriately part of treatment, developing a safety plan, including referral to a shelter where appropriate, and dispensing information about DV and necessary social services can be an important part of treatment. Confrontation clause. See if I can make a long story short on that. Basically, the confrontation clause says that even though a statement which is hearsay might be reliable, it ain't coming in if it's testimonial in nature, meaning that its primary purpose is that it was obtained for the purpose of gathering information for likely use at a subsequent trial, right? And it comes from a witness who's not testifying at the trial, but who doesn't qualify as unavailable and for whom or against whom there was no prior opportunity for cross-examination. So if that's the primary purpose, it ain't coming in unless that witness testifies and is subject to cross-examination, because that's the whole point of confrontation. However, if it is established that that out-of-court statement from that declarant who is not testifying in this trial was made for the primary purpose of helping the police meet an ongoing emergency, such as when there's a 911 call, my boyfriend is beating me up, or whatever the case might be, then it's not gonna be deemed to be violative of the confrontation clause. Same thing with a lot of these statements made to doctors and medical professionals, where they say the primary purpose is not to try and develop evidence for use at a trial, but rather to diagnose and help treat the patient who may be in a state of physical distress. Okay, so, and then I've already talked a little bit about expert testimony. There's a laundry list of cases that you can read, starting with People versus Taylor and Banks. Incidentally, and I know I've mentioned this in other presentations, when it comes to the rules of evidence, if you go to New York courts, nycourts.gov, there is a most recent compilation and statement of the rules of evidence. I know this because I'm a member of the committee. With annotations. So, for example, if you go to expert testimony, and by the way, there is a jury charge on expert testimonies and syndrome. Cases like Taylor and Banks will be cited. But if you go, if you have an evidentiary question, you need to get on first base. Go to newyorkcourts.gov, rules of evidence. They're not completed, and it's not every rule of evidence has been brushed up, so to speak, and presented, but most of the important ones are already out there. This is a laundry list of cases on expert testimony. I'll just pick one out of the hat there, People versus Henson. That was a case of a 4.5-year-old boy who had all kinds of old and new injuries. Parents said that the child was accident prone. Expert testimony was admissible on battered child syndrome and the type of things you're likely to see in a child who's been victimized or abused over time. Then, if you want to know what the bail options are when you're dealing with DV and sex offense cases, this gives you a quick synopsis of that. This People versus Soto case is worth reading. It's hot off the presses from 2020, where the judge went through a rather lengthy analysis of the new bail laws and domestic violence laws. And even though this defendant was accused of choking his grandmother, who he had done this to before, there were multiple DIRs. He has 2 prior misdemeanor convictions for DV, prior bench warrants. The judge released him on non-monetary conditions, but put him under pretrial supervision, order of protection, and had to attend counseling. I would think that most judges around here would have said high bail on this guy, and he'd still be sitting. But be that as it may, that's a case worth reading because it addresses the issue of bail in a DV context, and it's not much more than a month old. And this is our, I think, last code number for the television viewers. I talked about Bon Giovanni. Sheila talked about orders of protections, or temporary orders. That's 530.12, worth taking a look at. 530.11 is talks about family offenses and orders of protection, what the local court can and should do if a defendant is returned on a warrant issued by Supreme and Family Court. Appearance tickets, you can read that. It's most misdemeanors and felonies are mandatory appearance tickets, except there are some exceptions. When you're dealing with sex crimes and family offense crimes, the judge or the cop does not have to issue an appearance ticket. Or if it's likely that there's going to be an order of protection, no appearance ticket is likely to be issued. I mentioned earlier, and Sheila mentioned the sentence options. I've laid those out for you in these pages. You're welcome to read those if you represent a client who's a victim of DV. I threw this in there because it's at least tangentially relevant to the subject matter. So if you want to know when and how you can cross-examine a rape victim regarding her prior or his prior sexual conduct, very strict rules about it, so it's worth being aware of. And this is kind of, I'll end where I began. This is the mantra. You need to be aware of it. You need to be educated. Consider expert witnesses, because this is quite a challenge handling these kind of cases. And you have nothing but my admiration for doing this stuff. Thank you. And now I'd like to give you to get a real true-to-life perspective by somebody who's been able to negotiate his way through and around this court. And when I was asking people who would be a good lawyer to do this, they came up with somebody else. But no, actually, no. Dean's name was mentioned by more than one person. It was totally unrelated one to the other. So I said, okay, they must know something that I don't. So thank you, Dean, for being here.
Thank you. What can I say about Judge Franzak that hasn't already been said about coronavirus? I just have to tell you, I go back to Judge Franzak. I went to law school a little later. I feel funny because you guys are all experienced attorneys and y'all know what you're doing, but I maybe can tell you some of the stories that will help in IDV. But I went to law school a little later in life, and Judge Franzak was teaching trial techniques, and I took his class, and it didn't fill. It was the only one that didn't fill. And the reason was he had a reputation as being a challenging grader. And law school students were interested in getting H's at the time. I don't know how to do it now, but it was the H or A or whatever it was. And yeah, he said out loud, I'm in his class, he said, I wonder why I didn't fill up. And I said, give an H out once in a while. and he did. He did. Yeah, I did. First one. Then he filled next time. So I've been practicing in IDV as it exists now with Judge Henniges since she was elected. Actually, I knew her prior when she was at family court and Ann Boland and such. And I think I was one of the first folks from assigned counsel who was on the IDV panel, if you would. There weren't too many of us. And the reason it is difficult. It's a difficult place to practice because the rules are a little different. Judge Franzak just talked about rules of evidence and how there are exceptions, particularly even now on bail. There's always been a different perception. And first of all, I want to say that I don't think the perception that's out there, and I know it's being recorded, I don't mean to offend anyone, but that men are treated differently or poorly in IDV, I don't know that that's true. I think the problem is, as Judge Franzak mentioned, is that most of the time the aggressor is the man. So that's what happens. You get there. I've represented a lot of women who have been who've been the defendants, and they're treated, frankly, just as harshly, and if not more so on some of them. I recently had a 67-year-old woman, a oxygen conception. The judge was ready to put her in jail. I mean, it was really, she treated just as she did any other offender after things came to light. In any event, a few things that came to light as I'm sitting listening to Judge, those DV advocates, I'm not so sure about that. And again, not to be offensive, but their job there, they are believers, at least in the courtroom, at least when they're there. And they listen to the victims and guide them and advise them. And often they're more of an adversary to you than the district attorneys, who have their own job to do, and their position is, we don't represent this victim. That's not our client. It's the state of New York, and it's the people, and we don't care. So I have infused myself into some of those conferences when the district attorney says, I want to meet with the victim, and I've had the victims in a few of these cases as well. So I've sat in and listened, often over the district attorney's objections, and listen to what happens in those rooms. And frankly, it's a little disturbing because they will often try to almost encourage this individual, rightly or wrongly, but they substitute their judgment for them. That's all I can say. That power and control and the ability of an individual, a victim, to say to this court, I don't want an order of protection, it's not available. They don't have a say. It doesn't matter. I've had married couples, married with children, and a judge isn't an order of protection. And it's frustrating. And I say, well, just sign their divorce decree then, Judge. If you're going to issue an order of protection, they're married, they have kids. And she's here telling me she doesn't want an order of protection. but it still will be issued many, many times. And that's very difficult. It's frustrating. And it's challenging because now you've got clients who are just beside themselves. And they're not the easiest because many times, and again, I don't want to make light, but the defendants, many of them do fit a particular mold. It is a power and control thing, and they try to exert that over you, and it takes them a long time. The words accountability came in, and that's what the court's looking for. And many of these defendants simply will not take accountability. The blame is going to be on the victim. She did this to me. This is a toxic person. This is why it never would have happened had she not done this. True to life stories. She came at me with her nails flared and was going to scratch me, so I had to break her wrists to stop her. And they believe this. They believe this sort of thing. So you're dealing with that often. Maybe not that extreme all the time, but it's very prevalent. Very prevalent with this type of complaining. And then you've got the victims. And there's often a pattern with the victim too. And again, victim blaming will never work in integrated domestic violence court or pretty much any court. But it is definitely the wrong move to make there. Because the victims are often the types of individuals who, I think we've gone through I'm sorry, it's a honeymoon, I'll never do it again, and they say it's okay, and they come back. And the court sees it, they see a pattern. You'll see clients who are coming back year after year, or sometimes every 6 months, and there's an incident. And maybe it wasn't, not always physical either, it's not always physical. That power control often has to do with money or with personal freedoms, or I'm watching your Facebook page, I'm on your phone, you're not allowed to go out somewhere. So, you've got folks, the victim who's lived with this for their whole life, and it's almost like that rabbit that's boiled slowly. They don't realize at some point in time how absurd this has gotten and how much under control they are of this individual. And for those people, truly who need this kind of help, it takes them a long time. I have a client I've represented at least 6 years in my IDV. 2 or 3 times they've gone back. She's come back with this fellow, and never physical, but talk about power and control regarding money and movements and everything that this person does. And it finally, after 5 or 6 years, she finally separated. He'd been arrested on violation of order of protection because she would call him and say, "Can you come over and help? I got the kids in the town," and then there would be an arrest and back and forth. He's on probation. I think I think those kinds of situations have separated, but that's not unusual. It happens an awful lot. The other problem that we have in IDV, Judge Franzik again touched on it, was that presumption of innocence. I've always objected to, I'm going to release you, but I want you in a batterer's class. That's almost punitive. And I think something else that was mentioned, and again, I'll say these guys that are in these classes, in these batterer's classes, it's an educational program. It's not designed to change them. It's not counseling. They're not trying to fix them, if you would. And again, nothing concrete that I can hang my hat on, but I believe that a lot of the purpose of those classes, the real function is when somebody's ready to perpetrate a domestic violence again after going through one of those classes. Damn, I don't want to do that for 52 weeks again. Let me back off here for a minute. I think that's what really does impact somebody. Some of these fellows. I'm sure there's good educational information, but they're not changing. The studies have shown that. As you know, IDV used to do a 26-week program. Now we've got 26, I think it's 40 and 52. So if you've got a prior, you're not going to get a 26-week DV class. And the compliance has come back. We'll see how you do. The substance abuse is a big problem in this court. It seems. I want to say I can't verify the figure, but I'm going to say 80% of the folks that I represent as defendants there have some kind of substance abuse issue, or even if it wasn't a problem, that's what precipitated the incident. They were drunk or high, and things got out of control, and it may have been a single incident or repetitive, but often there's alcohol involved. So now, we can mention this is not a treatment court; it's an accountability court. I made the mistake once in that court of saying this is a treatment court, and that was not meant well. Nonetheless, we have a coordinator who sits right in the courtroom who has the judge's ear, who tells this judge what this person's doing in their counseling, what they're doing at their supervised visits, and frankly, giving judge the information I don't know that they really should be entitled to before his case is over. But it's the way these programs are set up, and the reason it happens is because the underlying concern is for a victim. So we'll always hear it's victim safety, and we're going to err on the side of caution. So you've got these things. You've got this coordinator to deal with. You've got the domestic violence advocates to deal with, and then you've got the district attorneys to deal with. I would tell you, I've taken this to the judge when the district attorney has said to me when I'm representing somebody as a victim, and the DA says, no, you're not allowed to come in when I'm interviewing them. So then you're not interviewing them, they're represented. Well, you're not representing them in a criminal matter. It doesn't matter, they're represented and they have a right to have me present, and they want me present. I've had a district, I don't want to tell too many war stories here, but I had a district attorney actually threaten one of my clients, a victim, that if she didn't come in and testify against her boyfriend, she was going to contact CPS. Had one of the DA's investigators go to the house with his badge and say, we're here, if you don't come in, I'm going to be back here and take these kids away from you because you're not cooperating. That's how intense it can be sometimes in IDV court, right? I lost my stuff with that one. And you know, I took that right to the judge. I think it was, it was unconscionable to do that. But again, you're dealing with very sensitive issues, and some are horrific. I don't have to tell you. You see them on TV. We just had the case where the young lady was burned, and that's still kind of kicking around. It's still over there because we've got kids involved, and they're trying to reopen that case so that they can fight severe neglect. But in any event, it is a difficult place to practice. Just like most of our cases, I want to say 98% of them are never going to go to trial. Maybe they should. Again, you folks have been around. We had certain DAs there who, in some opinion, were a little unreasonable. Can't get a reasonable plea, and so we have had trials. I would never. I think I had 4 jury trials there, and prevailed on 3 out of the 4. Do I think Judge Hennages, would I be afraid, again, word on the streets here, Judge Hennages or Judge Montour shouldn't have a bench trial. I don't know. They're certainly great jurists. They're very fair. But you always have to keep in mind that it's justice with that hint of let's make sure this victim's safe, and the victims always seem to have a little more credibility in these courts than maybe, in regular criminal courts. So I guess that's all I get. That's all I would offer. I've been practicing there, you said, like 14 years or so, and I've had all kinds of cases with them. I get along very well with the staff. I think that's important. Wealth of information, and again, I don't know how many of you actually go in IDV now and do some of the work, but the information that comes out in conference with the clerk, with Sheila or with Ann or whoever the clerk happens to be, it's really, you should have HIPAAs, you should have everything else for these things, but it's okay. It comes in IDV, even short of a trial. It comes in because the judge wants to ensure victim safety, and that's the underlying driving force in that court. So,
any questions of Dean?
Any success at all in circumventing the BIP, or is it just every single case? Because I know, I've done the research, it is not effective in changing the way that the defendant, acts in the future. And I know in our Article 10 cases in family court, sometimes we'll circumvent it by saying, well, they can address it in mental health. And that probably is a much more appropriate avenue to address it, so they can do some behavioral modification rather than just listening to somebody talk for a year. But
I got away with that and every now and then I can convince the judge that rather than ordering a certain program, that they're going to do a mental health evaluation, that domestic violence treatment or concerns will be addressed, and that the client will, if recommended, do that treatment. Unfortunately, again, probably more likely than not, it's going to be recommended to them. But I have been able to do that. And I've had a few who they came back and said, no, that's not really the problem. It was this, and we don't think it's appropriate, and it seems to be okay. So it is a punishment. Anything else? So thank you.
Thanks, everybody.
Was that closing?
You were.
All right.
You were the cherry on the cake.
Oh, yeah, I probably haven't seen it.
I'm at the point where I'm tired of listening to
Yeah,
you, so.
if you go out, it's like, maybe I'll
Jury trials. First of all, no way. They have video evidence.
Oh, yeah.
The court officer and the DA who are all witnesses, and the DA who videotaped it on the phone. Right after they signed their